The court took the position that in order for us to file for a temporary restraining order, essentially an emergency protective order against the city's enforcement of this new ordinance, that we had to bring what's called an order to show cause, an OSC, as opposed to a notice motion for preliminary injunction. That is a distinction that some would argue is not really necessary. However, the judge said that it was, and he's the man, so we're going to follow that. We're going to perfect that pleading and file an OSC. Unfortunately, it leaves us without the ability to get a temporary restraining order today, with the ban going into effect tomorrow. If all of these dispensaries close tomorrow as ordered by the city, then thousands and thousands of people will be without access to medicine, and this is a primary concern to us. And we're going to move as fast as we can to perfect the defects in the pleadings and to get back before the court. We realize the court has indicated that the court would be inclined to rule the same way had the pleadings been perfected. That is a natural thing that tends to happen. You have to go to the courts of appeal in order to seek redress of what a trial court does. We would not be surprised to receive in the city of Reading a denial from the local court for our request, and that was our anticipation, at least initially. So I'm not surprised about that aspect of it. And the issues here are due process of law. It's the taking of from a business without due process, without a hearing, without any notice, simply to have the city decide to extinguish these businesses without any rights at all. That's a violation of substantive due process under the Constitution of California and the United States. That's the issue we're getting before the court. Our procedural mechanism was defective according to the court. We're going to cure that, and we'll get back to the merits of it as soon as possible. Collectives have the opportunity to choose between following the edicts of the city and shutting their doors, closing their businesses, and continuing to have to pay their expenses like rent. Most of them have 90-day lease clauses in their leases, which will require them to maintain their storefronts, at least pay for them after the ban. The other option is they can stay open, and if they stay open, then they are currently subject to the code enforcement abatement proceedings that the city has available to it. That would be a mechanism by which the city would send inspectors by to determine whether or not they were still operating, and then they would cite them administratively and fine them administratively for their violations of the ordinance. How much damage can that accrue if they choose to stay open between now and the time we're able to get back in front of the court to request a TRO? I don't know. That's a question that we're trying to limit that time as much as possible so that the exposure to the fines doesn't become prohibitive in their ability to continue to operate and to provide the medicine that's necessary.